risk by removing their right to possess a firearm.
But the Ninth Circuit ruled that because Montana and federal law define bodily injury differently, convictions under Montana's statute do not qualify for the federal ban.
That tool, a very important tool to protect survivors of domestic violence, that tool is no longer available in Montana at the federal level.
The court said that Montana's law, which includes emotional violence, doesn't necessarily meet the federal requirement of physical force. The judges said they were bound by Supreme Court precedent and could only look at the definitions of the laws.
The Ninth Circuit decided this on a completely hypothetical case, not the case before them. And in fact, they couldn't find any cases, and none of the attorneys, when they asked them in oral argument, could find any cases in which a prosecution was solely based on sort of emotional harm.
That case was the firearms conviction of Michael DeFrance, which the court overturned. DeFrance's case stemmed from a 2013 PFMA conviction for assaulting his ex-girlfriend, Jermaine Charlo. She's been missing since 2018. DeFrance has not been named a suspect in her disappearance. But despite him admitting to physically assaulting her in 2013, the court said the state law did not meet the requirements for the federal firearms ban.
They acknowledge it's an absurd result, and they're asking the Supreme Court to change the law so that we can avoid these absurd results. More than absurd, dangerous.
In addition to the Supreme Court, Congress, the Montana legislature, and the state Supreme Court could all weigh in. King Reese said it remains unclear at the moment whether this will open the door for other Montana convictions being overturned or even other states' laws ruled ineligible.
There are a number of solutions. None of those are going to be quick. So in the meantime, as I said, I think survivors are more at risk than they were before.
In Missoula, Carolyn Weiss, MTN News.